Hello and welcome everyone to our very popular construction law case law update. We've had tremendous registration response to this webinar, so thank you so much. It's great to see so many members interested in these updates. Welcome in particular to new members, those who are joining an SCL meeting for the first time. We look forward to meeting you in person at our May meeting. I do apologise for appearing without a filter. This is unfortunately what I look like, but you won't have to suffer me for too long. Duncan Cottrell's hosting the webinar. It's also recording it for us. So if you feel you've missed anything, don't worry, it's going to be recorded for posterity. And you can't be heard or seen, but we have faith that you're out there. And for reassurance, please mute and turn off your video if you are eating lunch at your desk, so that we don't go back to those early days of COVID when everyone got to see everyone else doing that. And you can enjoy your lunch while you listen to our presenters. In terms of SCL notices, I just want to briefly touch on those. We have our 26 and 27 June New Directions, Navigating the Changing Construction Landscape Conference, and the 20th anniversary being held at Takina Wellington Convention and Exhibition Centre, and early bird registration for that closes on the 30th of May. A very sincere thank you to our conference sponsors. That's gone really well. We only have exhibition space available now. Rimkus, who are sponsoring the 20th anniversary and conference dinner, Anderson Lloyd, the Adjudicators Association of New Zealand, the Building Disputes Tribunal, Reflective Construction Law, Wim Williams, Duncan Cottrell, Badcock Law, Simpson Grierson, and Lawhawk. And it's really shaping up to be a fabulous conference. And you may be aware the government has passed the Overseas Building Products Standards and Certification Schemes Amendment Bill. And for our May meeting, we're delighted to have Rebecca Cook, Janine Stewart and Liz Hill update members on this new legislation. That is Auckland on the 15th of May, Wellington on the 20th of May, and Christchurch on the 21st. So please save a date, and registrations will be open soon. So turning to the webinar, the reason you're all here, I'll introduce each of our speakers in turn. Please save your questions to the very end. Use the Q&A function on the MS Teams platform, so with the two little speech bubbles, and to ask your question, and we'll see how we get on for time and allocate those as appropriate at the end. A link to all of the cases being discussed, together with a full introduction to the speakers, is on our flyer, which is on our website, and a recording of today's session will be posted to the members only area in due course. So welcoming our first presenter, Mark Holland, who is a partner at Hazelton Law. His practice encompasses adjudication, arbitration and court proceedings. He advises clients on contract negotiations, carries out contract reviews and bespoke contracts, and also advises on claim preparation for variations and extensions of time. He's a member of the Chartered Professional Engineers Council, and he is addressing the serious consequences of a construction contract having prohibited retention money clauses in the Stevenson Structural Engineers and Macmillan and Lockwood case. So Mark, if you would now like to share your screen, please give everyone a break and take over.
Thank you, Jonathan. We'll just believe that share, Jonathan. If you give me a nod, that would be good.
Yep.
Thank you. Thank you everyone for joining us today. I'm going to take you on a whistle-stop tour through Stevenson Structural Engineers and Macmillan and Lockwood. The brief background to the matter was that Stevenson's had 3 subcontracts with Macmillan and Lockwood prior to completing any of the obligations under the subcontracts. Stevenson Structural Engineers entered liquidation. One of the cash recovery steps taken by the liquidators was to seek to have retention money paid by Macmillan Lockwood on the basis that the retention money provisions in the subcontracts were prohibited by the Act. And the section which they particularly relied on was Section 18I, which we'll come back to several times on this. It's worth noting at this point in time that Section 18I remains unchanged after the amendments to the Act back in October 2023. It's also worth bearing in mind at this point in time, at an introductory note, that the fact that Stevens Structural Engineers was in liquidation didn't have any effect on the substantive judgment. It only came to be considered when we made submission on Section 310 of the Companies Act with regards to set off. So what was the clause which was at issue? This is a summary of the clause which was at issue, and as you can see, it had common provision for retention money to be released in 2 tranches. While Macmillan Lockwood and Stevenson Structural Engineers contracted under SA 2009, the previous form of the Master Builders Subcontract Agreement, the provisions on retention and release had come from Stevenson Structural Engineers' own terms and conditions. And it was the Part B, which is the section which was allegedly impugned. There was quite an amount of discussion as to whether it was also a conditional payment provision, which would have been prohibited under Section 13. And Associate Judge Skelton also considered that it was a conditional payment provision. But the main reason that His Honour considered that the provision was void was that it was linked to matters outside of the subcontract. That head contract practical completion had so many variables and so many matters which were outside the control of Stevenson Structural Engineers that it meant that it was making payment of retention money conditional on something which wasn't the performance of Stevenson Structural Engineers' obligations under its subcontract. To a certain extent, that wasn't a very surprising conclusion. One of the surprising matters about this case is that, considering that the retention money provisions have been in place since 2017, it's taken this long for a case to come before the courts where subcontract retention money is tied to head contract practical completion, considering the prevalence of those provisions in the industry. So just to move on then, this gives a visual clue as to what the subcontract looked like after Associate Judge Skelton decided that Part B of the retention money release was void. It was prohibited and void. It was contrary to Section 18I. We were left with a gap. And then that left a discussion with His Honour as to what the consequences of that were. The plaintiff submitted that the consequences were that the contract was illegal, but this was relatively quickly dealt with by His Honour. He said that it wasn't illegal and that the Act, the CCA itself provided for what the consequences were, that it was simply void, it did not exist. We, acting for the defendant, argued that the void, in the normal manner of things, could have been filled by an implied term. Associate Judge Skelton rejected this and said that this wasn't a provision that the parties hadn't considered, that could have been provided for. Rather, this was a situation where something which was in the contract, which was voided by legislation, and therefore, considering Supreme Court authority, Associate Judge Skelton considered this wasn't a situation whereby the gap created by the voiding could be filled by an implied term. And that then led to the very dramatic consequence. And without sounding glib, it's worth considering the retentions money regime in a subcontract as regulated by the Act as a house of cards. That if one card comes out, the entire regime comes down, the house of cards comes down. And it's worth considering that Associate Judge Skelton considered that the regime, and it's worth reading that in full, the retention regime under the subcontract is an indivisible whole. The provisions providing for release of retentions are an integral part of the regime. The provision providing for release of the balance of the retentions, 50%, after the issue of practical completion certificate cannot be ignored or severed. So His Honour considered that because it was an indivisible whole and it was incapable of filling a gap with an implied term, the consequence of that was that Macmillan and Lockwood had no contractual right to hold retention money at all. And therefore, the withholding of retention money all the way during the contract was something they were not entitled to do. His Honour decided as well that even though there was no contractual right to withhold the retention money due to the judgment, that the Act still applied with regard to creating a trust over that retention money. That His Honour considered that the definition of retention money in the Act was not dependent on there being a contractual right to withhold retention money. Therefore, if a person withholds retention money without a right to do so expressly in the contract, that creates a trust. And the fact that Macmillan and Lockwood was a trustee of the retention money that it withheld, notwithstanding there was no right in the contract, was quite significant when it came to the issue of what happened next. Just going to stop sharing because I've no more slides. So what happened next? We have a provision in a contract which is void. We're not able to fill it with a applied term, and we have no right to withhold retention money, but we're the trustee. Where a company is in liquidation, normally Section 310 of the Companies Act entitles a creditor to apply automatic set-offs to that money. However, His Honour held that no set-offs could be applied to that withheld money because Macmillan and Lockwood was a trustee. Because Macmillan and Lockwood was a trustee, there was no mutuality of the debts. And therefore, the substantial losses that Macmillan and Lockwood had arising from Stevenson Structural Engineers failing to complete the contract could not be offset against the money which was due, which would otherwise have been due to Macmillan and Lockwood arising from the liquidation. And it would occur to us that the same would apply in any situation where someone is seeking to apply a set-off where they are a trustee of the retention money which falls due in the end to be paid because the provisions are void. We made several additional arguments as to why the retention money wouldn't be due. Principally, although it wasn't finally decided, we made arguments that the trust over the retention money had ended. And the first reason why we said that the trust over the retention money had ended was because the liquidators has disclaimed the contract, as liquidators often do, which means that Stevenson Structural Engineering had no more prospective obligations under the contract, and prospective rights would never accrue. However, His Honour said that that didn't apply here because the right to be paid the money already under the contract had accrued before the disclaimer. But it does suggest, and His Honour did consider it arguable, that in a normal situation with a valid retention money regime in a contract where a liquidator disclaims a contract and the right to be paid retention money has not fallen due, well then ultimately the right to be paid that retention money will be disclaimed because it would never accrue. The other argument we made for the trust over the retention money being coming to an end was that Macmillan and Lockwood had validly terminated the contract, and that wasn't at issue. The subcontract provided for termination on an act of insolvency, which entering liquidation was. However, again, His Honour said that the right to be paid the retention money had accrued already, to be paid the money which had been earned under the contract. And therefore, the fact that it was arguable that the cancellation would have ended the trust over the retention money became a moot point. So the full threads are where a provision in a contract on retention money is void, certainly the right, certainly where it's in relation to when retention money is paid, it will deny a party a right to withhold retention money, and the entirety of the money which has been held as retention money will be immediately payable, and there will be no right of set off. What's less certain is what if a ancillary provision of a contract pertaining to retention money is void. And bearing in mind that Section 18I has got a catch-all subsection that says any provision in a construction contract is void if the purpose, or one of the purposes, is to avoid the application of any of the provisions of the subpart of the CCA regarding retention money. So, for example, if there's a provision now in a contract that purports to avoid the obligations with regard to accounting or reporting, does that bring down the entire house of cards as it's been described? A final point, which was argued and was argued quite strenuously on both sides, but His Honour did not decide on and is therefore still at large, is the issue as to what retention money can be applied. There is two schools of thought as to what a defect means under the CCA, because the retention money can only be applied to remedying a defect. One is that it's only physical defects, or two, it's to remedy any failure to perform under the contract. For example, could it be applied to damages for late completion? His Honour declined to make any judgment of that, because he said from what had gone before and the other arguments around when the trust had come to an end, that he did not need to make a decision on that. So that is still standing out there as something which needs to be decided on arising out of these proceedings. But ultimately, the message to take away from this is to be cognizant of drafting around retention money in contracts. It might be attractive to see this as something which is only relevant in subcontracts, but it's certainly something which drafters of continuity guarantees need to be cognizant of. Also with regard to head contracts where there are external approvals of retention money, perhaps from funders or financiers, those might also be provisions which are falling foul of the CCA, because you're making the payment of retention money conditional on something which is not the head contractor's performance under the contract. If perhaps you say that payment of retention money is subject to the approval of, for example, a core tenant or a funder or some other external body. So while this case appears to have relatively narrow application to the subcontracting sector, it is likely to have a broader reach. And that's me, Jonathan, as I promised it would be relatively short.
Great, thank you very much, Mark. That was fantastic. As you say, we've waited quite a long time for this type of clarification. It still leaves open some issues, but it is good to get guidance from the High Court on what the Act means and how to apply it. I'd like to now introduce our second speaker, Helen McFarlane, who most of you know as the SCL's president. Helen's a partner at Hesketh Henry, and her law practice encompasses both front-end advice on contract drafting and addressing issues that arise during the course of project from tender stage onwards. Helen read law at Oxford, was admitted as a barrister in London, then worked for 15 years in New York with leading US law firm Sherman and Sterling. And Helen's going to discuss how long is your long stop arising from the very recent Becker Carter Holdings and Furner Limited and Wellington City Council case. So Helen, the floor is all yours.
Well, hello, everybody. I think perhaps one of the questions is, do we actually still have a functioning long stop under the Building Act? So in a split 3-2 decision, the Supreme Court in the Beaker and Wellington City Council case confirmed that contribution claims are not in fact barred by the Building Act 10-year long stop limitation. And that rather a claim for contribution can be brought up to 2 years after the date on which the claim against the defendant is quantified, even if that is outside the long stop period. Now, what this case involved was a very, and I'm reading from the judgment here, 2 strongly worded, subject-specific statutory exceptions to an applicable scheme, each developed in response to a particular need. And what the court is saying there is that there was, in the Building Act, there was we have a statutory scheme where we're trying to actually, in Section 393, we're trying to get finality. So the Building Act is a statutory scheme that provides protection for building owners and the like. Section 393, however, is saying, but we need to have finality. So this is an exception to that. And the right to contribution is also a protection, an exception, because basically what it is giving is a primary tortfeasor the right to make a claim against other tortfeasors so that it doesn't have to bear the totality of the liability. So again, that is viewed as really a sort of a justice between the contributing tortfeasors. So these are 2 provisions that came into conflict, each with a fairly strong statutory justification behind them. And what you see in this decision is how that plays out. Now, just giving you a little bit of a background before we get into the detail. This was a dispute over the damaged BNZ building at Harbour Quays in Wellington. The designer had been Beaker, the structural designers had been Beaker. The Wellington City Council, of course, lucky it, was the Building Consent Authority, and the building owner was BNZ Branch Properties. What happened was that after the Kaikoura quake, the building was damaged. It was basically determined that you weren't going to be able to remedy it, and so it was just going to have to be demolished, and so litigation ensued. Now the timeline is this, which we've just put up here. So it was built between 2006 and to 2008, and Beaker issued producer statements in about 2008, I believe it was. A year later, the Wellington City Council issued the final of its various code compliance certificates for the bill. Then we had 2016 Kaikoura quake, and then in August 2019, the BNZ filed proceedings. Now you will know that was just within the 10-year long stop period as against the Wellington City Council. But it was 11 years after Beaker had issued its producer statement. So when Wellington City Council joined Beaker to the proceedings, Beaker said, no, Section 3932 of the Building Act, 10-year long stop applies. The council's position was, no, that doesn't apply to actions for contribution. So Beaker said yes, and Wellington City Council said no. Wellington City Council said that the separate 2-year limit under Section 34 of the Limitation Act applies. And critically, for that, the limit begins to run from the quantification of BNZ's claim. So that isn't even at the time that it is sued, that the council is sued, that functionally is a time when you get a settlement or a judgment that says, this is the amount you have to pay primary tortfeasor, in this case, Wellington City Council. So this was first, just put the whole screen up, both the High Court and the Court of Appeal actually found in favour of Wellington City Council. There had been some existing authority. There had been sort of some split decisions that had touched on it, but both the High Court and the Court of Appeal found that the 10-year limit did not apply to contribution claims. So it ended up in the Supreme Court. Okay, and here we get, this is what I was reading out to you earlier. We have two strongly worded subject-specific statutory exceptions. And then you had the plain language approach. So, basically, what the Supreme Court, the majority, was saying, there is no express override of contribution in the Building Act. It just doesn't say that. So if there had been intended to have Section 393 override the very specific rights created for joint tortfeasors, then you would have expected to see that. And there was none. So let's move on. What the dissent said in this, however, was that the legislative policy of the long stop was frustrated. So the legislative policy of the long stop was to provide certainty so that people could, in a sense, I guess, rest easy after 10 years. And this was just not going to be achieved if the long stop was less comprehensive than the plain wording. There are practical implications. The liability for an undefined period, the possibility of serial contribution claims. So, for example, somebody, the primary person who is found liable, brings a contribution claim 2 years after the long stop against a third party. The third party then waits until it's found liable for its level of contribution and brings a contribution claim against a fourth party. And so it could go on. The industry simply doesn't know. It's open-ended, unlike in just about every other provision where you have a 15-year long stop. In fact, the 15-year long stop doesn't even apply under the Limitation Act, doesn't apply to actions of contribution indemnity. So there are practical implications. And then there is a question of whether the unfairness to the primary tortfeasor is understated. Yes, it is unfair. And the point there is that, yes, it is unfair to a primary tortfeasor who is sued near the end of the long stop. But then, the long stop is unfair to owners whose late knowledge of building defects puts them outside of 10 years to begin with. So is that unfairness, which is really, if you like, the primary purpose of the right to contribution, is unfairness to innocent plaintiffs acceptable for certainty, but unfairness to the primary tortfeasor is not. So the position of the minority was that on its plain reading, Section 393 would apply to an action for contribution indemnity where it relates to primary liability that is for building work. And there is no reason why you shouldn't read it that way. So the minority basically said that if contribution claims are to be accepted, it should have been stated. So you've got, functionally, you have two very, very different views. And one is saying, the majority, that if you intended by this general language in the Building Act to override what had been a long history and separately developed legislation concerning joint tortfeasor rights with their own separate statute of limitation, limitation period. If the long stop in the Building Act had been intending to override that, it should have said so expressly. The other is basically saying that, on the contrary, that the broad natural reading of Section 393 is such that it would include contribution claims, and if those claims were to be accepted, then that should have been stated. So they're just poles apart. All right, but the reality is, move on, that we are now left with the decision of the majority, which basically says that the 10-year long stop doesn't apply to actions for contribution indemnity. So what is the position? Well, the plaintiff has to bring the main claim, that is the claim against at least one defendant within 10 years of the building work being done. So that the plaintiff is captured by the long stop. But the defendant can bring a claim for contribution against another potentially liable party after that expiry period of 10 years. It has to do it within 2 years that the claim is quantified by means of settlement or a court decision against us. So let's sort of think about this. We have in this particular case, we had a plaintiff who brought a main claim at the 10-year period, basically, against the defendant. The defendant then tried to bring its contribution claim. It actually had 2 years to do that. That it ended up bringing the claim 11 years after Becker had actually done the work in question. The final decision, or actually the court judgment, was some years after that, and then, or would be some years after that, and then we have the potential to bring in other third parties. There's essentially an unknown period of time in between the expiry of that 10 years and when the third party will be joined. So what does that mean for practicalities? Well, it certainly introduces a level of uncertainty. There is really no incentive on plaintiffs to join all necessary parties. And the reason for that is that if they lose against any party, then they're liable for that party's costs. So the plaintiffs really have an incentive to hunt out the deep pocket parties, sue them, and then leave those deep pocket parties to seek contribution. And that, of course, is what happens. Councils, plaintiffs typically will sue councils, and councils will then seek contribution and indemnity and join other parties, or seek claims for contribution against those other parties. And those other parties can be engineers, can be architects, often can be subcontractors, frequently can be smaller parties who might not have all the deep pockets, but the deep pocket defendant is likely to go after them. So what that means is that for those parties who can get insurance, like architects, engineers, professionals, they have to figure out, how long do I get my insurance for? And it's undoubtedly going to be pushing up the cost of insurance. For other parties who don't typically get huge amounts of insurance because they're not designers, they're not deemed to, they don't carry PI insurance like subcontractors, they just have a huge level of exposure there that continues on. So I think there are very legitimate questions here that probably, if there's one takeout from this case, it is that we have two existing statutory systems which have come into conflict, and neither the majority decision nor the position of the minority is really very satisfactory. Because these are direct conflicts, and one statutory scheme, if you like, statutory exception is going to have to give way to the other. There isn't any real sort of compromise. So it really, I think, is something that probably needs to be dealt with by legislation or stepping in. So what could that look like? Well, I've suggested a number of options here. One would be maybe a bespoke long stop for contribution claims. So there you would be amending the Limitation Act. Or, and I rather like this one, 2 years to run from when the claim is made against the primary defendant. I mean, I think one of the reasons why the 2 years is supposed to run from the time the claim was quantified is because that's the final act that is really done that enables you to be able to say you have a claim, or there's certainly a line of authority that would say that. But it doesn't seem unreasonable to require a defendant who is sued to bring any claims for contribution within 2 years from the time when they're sued, even if the claim against them has not been finally determined and quantified. That would at least give you, it wouldn't totally reduce the uncertainty at all, but it wouldn't totally eliminate the uncertainty, my apologies, but it would reduce it. Now, the other thing that I just want to throw in here, which is really something of a topic for discussion, is proportionate liability. We, of course, the whole issue of the need for contribution in the first place comes from the fact that we have joint and several liability. So you make your claim, you're a plaintiff, you make your claim against the council. The council is found, probably 25% liable, something like that. But you can recover against them in its entirety. And so, of course, the council is wanting to redress that total inequity against it, or whatever defendant you have happened to sue, who you think was a deep pocket, wants to redress the total inequity against it and seek contribution from other contributing fault parties who may be at fault. But, of course, if you have proportionate liability, then you don't have that. You don't have the need for that at all. But then, of course, the question would be, how would you make sure that actually all parties were at the table in the primary hearing in order to be, or at least the liability of all parties was considered in the primary hearing in order to be able to make a determination of proportionate liability? And probably the other issue there is it benefits tortfeasors at the expense of plaintiffs. Because basically in any proportionate liability system, the plaintiff, if there is some joint tortfeasor who is either insolvent or just is not able to pay its contribution, the plaintiff wears that. So this is another, putting on, on top of the fact that the plaintiff is caught by the 10-year limitation period, this would be making it even harder to recover. So that is another question that will go into the issue of whether proportionate liability might be a statutory mechanism to resolve this. But that is a question for another day. So I am going to close out now and turn on to the next speaker.
Fantastic. Thank you very much, Helen. That was awesome. I mean, it is, I suspect, something that there's going to be a bit of a clamour for clarification, because there are tensions that pull both ways on this. And it is, we are talking about now quite long time frames after the original event happening, which will have implications around document retention and insurance and all sorts of other things. I'm lucky last. I am Jonathan Forsey. I'm the SCL Honorary Secretary. I'm also Special Counsel at Duncan Cottrell's Christchurch Litigation and Dispute Resolution Team, which has been my main focus throughout my career, various dispute resolution forums. And I also work with clients on risk management, preparation and updating of policies and training. And I'm going to talk about problem producer statements potential penalty path. And the reason why I gave it that title is because the actual name of the case is quite confusing. It is, just in case I haven't done my sharing. Okay, so the actual case name is Solicitor General's Reference Number 1 of 2022, which is a Court of Appeal decision that came out last October. And what the Court of Appeal was dealing with was potential criminal liability for producer statements, and the court upheld that there is potential criminal liability. So the Court of Appeal confirmed that issuing producer statements is building work under the Building Act 2004, and that authors of producer statements now have the potential to be criminally liable under Section 40 of that Act. So what does it mean? Well, the court held that parties issuing producer statements are doing more than giving an opinion, which was one of the main arguments raised. The court held that they reflect the work the author has carried out to express the opinion, as well as the opinion itself, and confirms that the author has reasonable grounds for belief and compliance. And this means that the authors of producer statements must take care to ensure they can point to the reasonableness of the grounds for belief. It highlights the importance of record keeping and site monitoring, particularly at key stages if you're issuing producer statements, and authors should very carefully consider whether they have all the necessary information available to them when statements are signed off, something which can be difficult in practice where there are acute time pressures, and particularly where there's reliance, as there often is, on third parties who in turn have provided their own statements. So the thing that we're talking about is this beast. This is a PS4 in the standard IPNs form. And when I say standard IPNs form, one of the issues here, of course, is that we're not talking about a statutory instrument. So how do we get here? Well, the Court of Appeal was referred the question by the Solicitor General. Was the court in the Kantian and Tauranga City Council case correct to find that the issue of producer statements following or as a result of construction monitoring in relation to non-compliant building work does not give rise to liability under Section 40 of the Building Act? And the Court of Appeal said no. So the Court of Appeal said that the High Court was not correct in that instance. So the question was seeking clarification on the application of Section 40 because of conflicting decisions. And whether that section applied to producer statements or not. And the answer depended on the interpretation of building work as it appears in the Act. And section 40, which I've set out there in the slide, building work must not be carried out without consent, and you must not carry out building work except in accordance with the building consent. Person commits an offence if the person fails to comply. And then there's the penalties in subsection 3. That's the development that we're talking about in Tauranga, which had a rather unfortunate hiccup and resulted in significant litigation. So the relevant facts are that the charges were laid against a Mr. Cameron, who was an engineer who issued producer statements in connection with a residential subdivision and development near Tauranga known as the Lakes. His role involved on-site construction monitoring. He did the testing and giving instructions and directions to building contractors. And so Mr. Cameron and a company, the Engineer Limited, which is an engineering company engaged by the principal, were both convicted of carrying out non-compliant building work. And the basis for the charges was that they had provided the council with producer statements, in this case PS4s, related to restricted building work carried out at the site, which did not accurately reflect what had been done. So in other words, the certified work did not match the activity that was carried on site. And the district court found that Mr. Cameron and TEL were liable under section 40 for issuing producer statements, while the High Court disagreed, and the conflicting authority prompted the Solicitor General to seek clarification, which is how the Court of Appeal became involved in the narrow scope that I've just set out. The Court of Appeal noted that producer statements do not have a legislative basis. They did, of course, under the previous Building Act, but not under the 2004 one. But they are routinely issued and relied upon in the construction industry. And this is a quote from the court. The Act doesn't provide for producer statements, unlike its predecessor, the Building Act 1991, commonly used to advise building consent authorities about construction work that has been carried out in the course of implementing building consents. Their provision by suitably qualified persons may be accepted by building consent authorities as an accurate representation of work that has been carried out and is giving reasonable assurance the work has been carried out in accordance with the building consent and the building code. This process enables building consent authorities to reduce the cost and delays that would be incurred if they carried out their regulatory functions under the Act using only their own employees. So it's notice of the universal practice of reliance on producer statements and essentially elevating the standard form of those producer statements to being something which the territorial authorities all rely on. And they are usually issued in standard form, like in my previous slide. They are regularly issued and relied upon by the construction industry throughout the industry. They're always required to be provided, and you can't get a consent without them. The court accepted that the issuing of producer statements amounts to carrying out building work for the purposes of the Building Act 2004. So although it isn't a statutory document, a producer statement is a standard document with well understood content and purpose. I should add there, so well understood the Parliament didn't see fit to say what that was when the 2004 Act was passed, intended to contain reasonable statements of professional opinion that the building works to which they relate have been completed in accordance with the building consent and the building code. So the court said that the work necessary for producer statements to be completed fell within the definition of site work. So people signing them off are not just ticking a box, they're actually performing work to satisfy themselves independently that the work carried out on site, and this is another picture of the same site, meets the requirements of the Act and Code. So it was actually a pretty straightforward exercise from the court's perspective. They didn't accept that a producer statement was just opinion. They didn't accept any of the limitations that are commonly recorded on the producer statement itself as to the limited warranties or limited representations made by the author. They basically said if you sign it, you are responsible for what's in the tin, and if it transpires that the work is not carried out in a way that meets the requirements of the Act and Code, then you are potentially criminally liable under the Act for having breached the Act's requirements. So the court didn't envisage a sudden surge in criminal prosecutions. But the case is a useful summary of the significance of producer statements in the consenting process, despite the lack of a formal statutory framework. And the court said that building consents and the building code have prescriptive and verifiable standards as to what they each require. The author of the producer statement will not be criminally liable unless it is established beyond reasonable doubt, so that's the criminal standard, that the matters certified in the statement are incorrect. And in the present case, Judge Mabey was readily able to conclude beyond a reasonable doubt that the producer statements were wrong. And if that standard could not be met, no offence would be committed. So the court's relying on the fact that the criminal standard of proof is quite a high one. So you would need a situation where the person signing off the producer statement wasn't able to substantiate the basis which enabled them to do so. They are a routine part of the construction industry and relied upon by many. And this decision highlights that it isn't a rubber stamping exercise, and it emphasises the importance of getting them right, as the sanctions from getting them wrong now go beyond civil liability or potentially disciplinary liability for engineers or for other practitioners involved in providing statements. With the comments this morning from Minister Penk about the move to self-certification, it's interesting to think about whether an exercise in self-certification by particularly selected builders would fall within the same category as being work which in itself, that self-certification, would be considered to be building work, and that criminal liability would potentially apply in the event that the work was proved not to have been carried out despite what the self-certification subsequently said. I'm just raising that off the top of my head as a topic which arose when I was listening to the Minister talking on Radio New Zealand this morning. But I can't see any reason why the court wouldn't take the same approach. So short points to take away: producer statement, not just a matter of opinion. It's a key ingredient of the consenting process. It isn't a creature of statute, but everybody understands what it is and what it requires. In the view of the Court of Appeal, the use of standard forms means that it's all completely stable and reliable as something that territorial authorities ought to be able to rely on. And if you sign one off, it is you that are personally responsible for having ensured that all of the building work has been carried out. And that will, of course, rely often on being satisfied based on certifications carried out by others, unless you've been on site the entire time. So desktop assessments will be an interesting balancing exercise for people between expedition and the supervision of sites, especially where you've got one person certifying a very large amount of work. So there are still potentially some interesting issues to come in this area, but again, it is useful to get this kind of clarification. That's the end of that presentation. I'm going to stop sharing now and just pop back into the main screen. We do have time, approximately 6 minutes, for any Q&A. One of the questions I promised I would ask Helen if we didn't have any questions was around proportionality, but Helen did touch on that towards the end of her presentation. But one question which I've belatedly fed into the Q&A, which I will put to Helen now for her to respond to, is does the effective demise of the long stop have implications for how long parties need to retain documents far beyond what was previously considered necessary?
I would say yes. In short, absolutely. If just as a practical matter, I think that in order to be able to properly defend yourself if you are sued, it makes sense to actually keep your records. Because by and large, as we all know in construction cases, good records are what are going to help you more often than not. Of course, they can sometimes harm you. So on balance, I would say, yes, it would be prudent to be keeping your records for longer than 10 years.
Which raises problems for people that have put in place contracts with third-party providers where their documents are stored in the cloud or in electronic systems that self-delete after set periods of time, often 7 years or less, because of the cost of electronic storage of site records, which is very data heavy. So you might wind up with no staff remaining and no records.
Exactly. But it's a trade-off. It's a trade-off of how likely you think it is going to be. It's a trade-off. If you don't have staff remaining and you don't have any records, then you're really going to be quite screwed in trying to defend yourself. Yeah. And that's the bottom line. But maybe it's the cost of keeping all of those records, etc., is just ridiculously prohibitive, and so you take the risk. But it is certainly something that you need to factor in to your decision as to how long you are going to keep records for. I actually had a question for you.
Oh, okay.
What about the situation where you actually genuinely do have reasonable grounds for your belief? I mean, and I guess one of the things you're talking about some of the times is relying on other people's certificates and not actually standing there and watching every single thing being done while it's being done. What if you actually do have reasonable grounds and demonstrably reasonable grounds for your belief, but it's still wrong?
I think the Court of Appeal's position is that wouldn't expose you to criminal liability because you wouldn't meet the criminal threshold. You would have a reasonable ground for belief. You would have other producer statements from other parties. Yeah. You would have notes and site observations, even if they weren't perfect. If you missed something or you got something wrong, but for most of the time you were there or you did get the right bits of paper. If you could point to the fact that other people's certifications were themselves in breach of their obligations, there wasn't any of the consented protections or supports in the foundations where they were poured, or people hadn't put in structural steel where it was specified in the diagrams, and then you have an engineer who's a CPeng signing off that it had been, you would point to that as a reasonable grounds for your belief that the building had been completed to the standard required, or the consented standard, and therefore also the standard required by the Act and the Code. I think it was here that the evidence at the district court level was so egregious as to the failings of the engineer named and the engineering company to just basically rubber stamp producer statements without having ensured that any of the work was done to the required standard. And that's how things got on as far as they did in the development. And the council was really caught on the back foot because they relied on these things, and they turned out not to be worth the paper they were written on.
So really the takeout then for engineers and consultants is, make sure that you have a really good document trail to support your reasonable belief.
Yep. Yeah, really, and especially if you are the person signing it off, because the responsibility is personal. You can't hide behind a corporate responsibility. And if people are angry enough, they will pursue this. Now the Court of Appeal said it's there. It is another thing that would have to be explored in an extreme. Well, I won't say extreme. That gives, because the court's not saying that. But if there is evidence of it beyond reasonable doubt of a failure to meet the Act and the Code, there have historically been those failings, of course, in buildings constructed without specified barriers or waterproofing or insulation or all those sorts of things. So I'm not saying it doesn't happen, but you would have to prove that that the person signing it off had got it badly wrong. I've just got a quick question which came through on the Q&A about whether the same thing would apply in the context of principals being liable. I presume the question is criminally around payment schedules and payment claims. That those issues, I don't think, and I'm not giving legal advice here, you could take your own from one of the other 90 odd people on the call. that wouldn't involve building work. That's an issue of compliance with the payment claim and schedule regime under the Act, but that doesn't involve building work in terms of the site construction. So it isn't a Building Act issue. It's a Construction Contracts Act issue.
Yeah, I think, Jonathan, I think the question there is rather than to do with the criminal liability, whether whether the engineer has failed to issue a payment schedule and the contractor is provided for that circumstance where the contractor is compelled to follow the steps before they seek to enforce the unanswered payment claim. I think just to actually answer it, the question there would be what the terms are, and ultimately a court will decide when the payment schedule was due. If the payment schedule hasn't been issued on time, irrespective of what the steps are on the contract, whether it's a provisional payment schedule or otherwise, I think that if it's not answered, it's not answered. And in the final question there, it says, is it fair for the principal to bear the full payment obligations due to an error made by the engineer? Yes, that is the short answer. If you appoint an agent to issue your payment schedules and they fail to do so, even though no doubt they've been practicing since the Tyrannosaurus Rex roamed the earth, of course you do bear the consequences, yes.
Yep. Well, I think that's a nice firm ending for today's presentation. And so I'd like to very much thank the presenters for their time, and also thank everyone for joining in. Hopefully you got something out of that. And we look forward to hopefully seeing you at the conference, which will be great. And also we'll get the information out about the May presentations to members shortly. And have a fantastic and safe day, everyone. Thank you very much. And thank you to the IT teams that have made this possible, wherever they may be. So thank you for flawless assistance in this. Cheers.
Indeed. That is seconded.
Thank you.
Cheers. Thank you. Bye.